Testing, this is a test of the Seventh Circuit.
Good morning, everyone. Our first case for argument is United States versus Bell, number 242198. Mr. Jensen.
Please, the court. My name is Attorney Jeffrey Jensen Sr., and I represent the appellant Dion Bell. Dion Bell, in around 2017, was convicted of a number of state offenses in Wisconsin. They were not the offense for which he was charged in federal court. They were operating an auto without owner's consent, some possession of drug counts, things of that nature. He was convicted and sentenced to a period of initial confinement, and then he was released on extended supervision. In May of 2022, he was still on extended supervision from the state court in Wisconsin when agents arrested him and he was charged with the present case, the case we're here for today, in federal court. He remained in custody from that day, which was May 13th, 2022, until he was sentenced in the federal court. The reason he stayed in custody was because, based entirely on the fact that he was indicted in federal court, the state court revoked his extended supervision and imposed some time in prison. He was serving that prison time the whole while that the federal court was pending, up until about a month before he was sentenced in this case. He was convicted of...
Mr. Jensen, wouldn't we have to overrule our precedent in order to find in your client's favor?
I don't believe so, because I believe this issue is controlled by a series of cases. First of all...
Well, how do you deal with United States versus Cruz, for instance?
Well, Cruz, the main point of Cruz, I believe, is that the language between the Armed Career Criminal Act and the minimum mandatory penalty for possession of drug counts is different. The drug case requires that a sentence be imposed.
Yeah, but they all deal with the difference between a discharged and an undischarged sentence.
Right.
And here there's no question as to Mr. Bell's status at federal sentencing. There's
Yes.
no dispute, right, as to that.
I believe that discharged and non-discharged language comes from 18 U.S.C. 3584, which talks about concurrent and consecutive sentences. And then I believe it was in Campbell or Cruz, the court talked about the 5G 3.1 sentencing guideline does not restrict the sentencing court's discretion. It's just advisory. And that it is 5G 1.3 that says the court may take into account non-discharged state sentences in lowering the federal court sentence. And I think
that's great, but that doesn't get you around a mandatory minimum. And it seems to me, if I can just cut to the chase here, that neither 3584 nor 5G 1.3 address this case. And that if you've got a textual argument for consideration here, it's based on that difference in wording between the drug and the gun offenses.
right.
As acknowledged in Cruz and as discussed, was it Ross, I think, where the opinion noted that said in essence, we don't care, the statute doesn't tell us how or when you serve your 15 years in prison.
Right. Ross was the first case on this issue, and it was published in the year 2000. And in the concluding paragraph, the court said, "We conclude the computation of the total term of imprisonment for purposes of 924E, which is the Armed Career Criminal statute, consistently with the application note, may be accomplished by adding up the number of months the defendant has served on the related conviction and the number of months assessed in the federal judgment." At least in Ross, the court didn't say anything about non-discharged or undischarged sentences. I think it stands for the proposition that the Armed Career Criminal Act requires a certain amount of imprisonment, but not necessarily a sentence. And so for that reason, the district court possesses the discretion to lower the sentence below the minimum mandatory 15 years, as long as the amount of the related state time and the amount of the federal time equals 15 years. And I addressed this in my reply brief, and I think one of the main reasons that undischarged, non-discharge, or discharge is irrelevant is because this isn't consecutive, a question of consecutive or concurrent. It's a question of lowering the sentence in federal court. Normally, when a sentence is run concurrently, the judge will say, I hereby sentence you to 15 years in prison, concurrent to any time served in the state case. But in this case, the Bureau of Prisons will not give Mr. Bell credit for the time he served under the state case. So I think for obvious reasons, the government focuses on the non-discharged, undischarged language, but I think that is not relevant. The question is, does the district court, the federal court, possess the discretion to lower the sentence below the 15 years as long as that, combined with time served under a related state case, equals 15?
And for your argument, is there no temporal limitation? Here, the related state case had just finished up 2 months earlier. But say the related state case had finished up a year earlier, 2 years earlier. Was it all the same to you?
Well, it depends on the facts of the situation. If the person were revoked in the state case solely because of the federal indictment, in other words, it's a related case, then I don't think it matters how much time passes from the discharge of the state sentence to the sentencing in federal court, whether in this case be a month or, in your example, a year. Of course, it makes a huge difference whether the person was revoked because of conduct for which he was charged in federal court.
One of the things that concerns me about that theory, Mr. Jensen, is it's easy in this case, right, to decide that the two cases are the same, based on the same conduct,
Yes.
right? Those 2 years in state prison, what counted towards state custody was based on exactly the same conduct. How close does that have to be? And how would we decide that the next time around? For example, if somebody's revoked, maybe there are drugs and guns involved, and one of the charges is felon in possession, and another is possession of drugs with intent to distribute.
Well, in my mind, that's a question of fact, and courts are well accustomed to determining questions of fact.
But what exactly would be the question?
Whether that, and it was kind of discussed in State versus Campbell, where this court reversed the sentence and remanded back to the district court, and then sort of by way of explanation, the court went on to say, by the way, you should make detailed findings about whether this earlier offense was related to the federal case. So that's where I get the idea that
That's just us making up the law, though, right? I mean, there's no statutory authority for that. There's no Supreme Court case that you can cite to. That's just us kind of flying by the seat of our pants. And
Well, wouldn't characterize it as flying by the seat of the pants, but I think it's valuable instruction.
well, what's the best Supreme Court case or statute you have that allows us the authority to do that?
Well, I have to concede I don't have a Supreme Court case or a statute that guides the court's discretion in determining whether or not the state time is adequately related to the federal time. But
I mean, what's the best authority that you have that says we should even consider that as a factor? That's a factor.
United States versus Campbell, I think the court discusses it. And I reserve 2 minutes, and I'm already over my time, so I'll pass the floor to Mr. Martini.
I thank you, Mr. Martini.
Thank you, Your Honor. Good morning, and may it please the court. Fadis Martini on behalf of the United States. Congress recognized that a subset of federal criminal defendants would be subject to overlapping terms of imprisonment. So it gave district judges the discretion, or at least codified the district judges' already existing discretion in Section 3584 of Title 18 to impose new terms of imprisonment, either concurrently with or consecutive to other terms of imprisonment. But crucially for this appeal, other undischarged terms of imprisonment. Under this court's precedents, an adjustment to achieve what the court calls a fully concurrent sentence is nonetheless possible in cases involving minimum mandatory sentences, even if that involves an adjustment at least nominally below a particular mandatory minimum term specified by Congress, so long as the total term of imprisonment meets that fully minimum mandatory term, all aggregated together. But, and again, this is the crucial point for this appeal, this authority exists both under this court's precedents and through the statutory authority granted by Congress when that prior term of imprisonment has not yet discharged. In this case, Mr. Bell seeks a 2-year adjustment. We've heard some discussion about that already here this morning, and that's to account for a state revocation term that he completed, just pure happenstance, about a month before he was actually sentenced in this case. The district court correctly declined to grant that credit because, for better or worse, the law simply just does not allow it under the circumstances of this particular case. Mr. Bell argues that this isn't a question of concurrent sentencing. He urges the court to focus really almost entirely on sort of the aggregated total term. But the court's decisions, again, are very clear that the kind of adjustment that he asks for is rooted in Section 3584. Section 3584 is a link in the chain. And the concurrence is really, it's actually quite important to Mr. Bell's case because it's the way around the minimum mandatory term.
Mr. Ferris, could I ask you, suppose the federal sentence had been imposed here a week before the completion of the state 2-year revocation sentence. Would the district judge have been able to take off 2 years or just 1 week under those circumstances?
Your Honor, under this court's precedents, the district judge would have been able to run the ACCA 15 years fully concurrent to the state revocation term. And so the district judge would have had the discretion, the authority, again, under this court's precedents.
Well, he wouldn't have imposed a concurrent sentence. He would have said 13 years, right?
He would have said there's some instruction in the guidelines about how a judgment that accounts for this kind of adjustment should be structured. And I believe Your Honor is correct. I believe that at least nominally what the court would have imposed, recognizing that the Bureau of Prisons wouldn't provide credit for that state revocation time, is a 13 year and a week.
Yeah. Okay. And would you agree with me that if the sentence is imposed a week after the expiration, the federal sentence is imposed a week after the expiration of the state sentence, that under your theory, then it's got to be full 15 years, no credit for the state, and so that timing certainly looks pretty arbitrary, right?
That's correct, Your Honor, and that's the result that's compelled by the statutory scheme.
Well, maybe not. That's the question in front of us. But it clearly is arbitrary. We know that Judge Stantmuller in this case wanted, if he had the discretion, would have given him credit, right?
That's correct, Your Honor.
He was very clear about that. So why can't we just focus on the language in 924E about in the case of a person who violates, et cetera, the person shall be imprisoned not less than 15 years, and say, as we did in Ross, we don't care exactly how that happens as long as you get the 15 years.
Your Honor, the reason for that is simply that there's just no statutory authority to go below the minimum mandatory term when there's no concurrent sentence. And Campbell, Cruz, and Hernandez's interpretations and their follow-on commentary on Ross makes that very clear. Now, one thing a few circuits have allowed what I think we kind of colloquially refer to as a Campbell adjustment, the type of adjustment that Mr. Bell seeks here, the type of adjustment that the government concedes is appropriate in cases where there's a concurrent sentence. It's worth noting that Ross and the other cases where all of this kind of begins happen against the backdrop of what at the time was a mandatory sentencing guidelines scheme. And it makes sense in that regard that, you know, we start with 3584, that incorporates 3553A, and then 3553A instructs district courts to look towards the guidelines. And so it kind of makes sense that that's where all of this starts. But at the same time, I think in a case where you have a discharge sentence, there's just no statutory hook to go around the minimum mandatory sentence. That's the more specific provision, and that's the provision that governs above all others. And it creates the potential for a lot of kind of strange outcomes if, you know, any prior term of imprisonment can be counted as imprisonment under the words of the ACCA statute. You know, for example, you could have a scenario where someone would argue a prior term of imprisonment would count towards a statutory maximum if the word imprisonment on its own, without some other independent statutory hook, without some other enabling, I think the Fourth Circuit in Moore calls it the enabling statute, is 3584 in this case. Without something else, there's really just no limiting principle there.
Well, the limiting principle would be, is it for the same conduct, right?
That could be one limiting principle, Your Honor, but at the same time, there's just nothing in any statutory or case law that would provide the basis for that kind of distinction.
How would we know if it was the same conduct? How would we have any clue? I mean, a gang investigation, for instance, it lasts 6 years. A defendant, a search warrant is conducted, guns and drugs are recovered, but no arrest is made because they're lower members of the gang. They're going to go up on a Title III. But the state court revokes a defendant's period of supervised release or probation and puts the defendant in jail for 18 months for possession of guns and drugs. 3 or 4 years later, the defendant is indicted. There's a 924C charge. How would we have any idea to determine the basis for the revocation of supervised release?
So that's one potential issue, Your Honor, and you know I think as discussed a little bit earlier, it's not really an issue that we necessarily have in this case, but that's one reason why this sort of, I think Mr. Bell argues at some point for again a framework where if something's reasonably related to the new sentence, it can be counted as the new sentence's term of imprisonment, and that's precisely one problem. Now the guidelines deal with
If we
this.
just say reasonably related, that's going to be a quagmire.
Sure.
If we say the same conduct, for example, if you've got possession of a firearm that leads to the revocation of the state sentence 3 years earlier, and you've got possession of another firearm that leads to the federal indictment on a different date, no problem, right?
Your Honor, Congress could write a statute that would allow for that kind of adjustment to account for the same conduct in a case, as Your Honor suggests. But even in a case like that, I mean, this case is actually a pretty good example. Mr. Bell was revoked for possession of one, not both of the firearms that he was ultimately convicted of possessing. The other parts of his revocation also extended to allegations that he had absconded from supervision, that he had consumed alcohol. I'm not here suggesting that the reason he was revoked for 2 years was his absconding from supervision and his consumption of alcohol. But that it just illustrates the point that it's difficult to sort of parse those things together and figure out what is the same conduct in any given case. Now the guidelines, of course, deals with this a different way through the framework of relevant conduct. But even under that framework, there's no authority to go below a minimum mandatory sentence when the prior term of imprisonment was even for relevant conduct. And Cruz makes that abundantly clear. That's a case in which the prior state term involved activity that was relevant conduct in the federal case. I believe in Cruz it contributed to the calculation of the guidelines in the federal case. And the court said, unfortunately, because the prior term was discharged, there's just no authority there. Section 3584 is the critical link here. It applies only to undischarged sentences, and the district court correctly sentenced Mr. Bell in this case. If there are no further questions, we respectfully ask the court to affirm the district court's judgments below. Thank you.
Okay, thank you, Mr. Martini. Okay, Mr. Jensen, would you like to have anything else to add?
Well, I have 48 seconds, so I'll make use of it.
And at least one question from me, but go ahead.
Okay. Well, there was only one thing that Mr. Martini said that I believe warrants comment in a rebuttal, and that is that there is no statutory authority to sentence below the 15-year armed career criminal provision. And I agree with that, which is why I'm not here arguing that Bell ought to be sentenced below the 15-year minimum mandatory. I'm here saying that in United States versus Ross, the Seventh Circuit said, because of the language of that statute, we don't care when or where he serves the 15 years, as long as the state time and the federal time equals 15 years. That's my argument. So I believe there is statutory authority. In your honor?
Could you address Mr. Martini's point about 2 guns versus 1 in this case?
Yes, and I have 2 responses to that. First of all, I don't see how that matters in the ultimate analysis, because the government did not argue very stridently, or if at all, before the district court, that this was not related.
Okay. Arguments don't have to be strident, but that's a different point.
And Judge Stadtmuller made what I think is an explicit, if not an implicit, if not explicit, finding of fact that it was related, because he said I would have reduced the sentence.
The same gun. Yeah. Okay, thank you.
All right, thank you, Mr. Jensen. The case will be taken under advisement. Our next case, United States versus Santana, appeal number 232695. Ms. Turner, whenever you're ready.
Good morning. May it please the court, counsel. My name is Denise Turner, and I represent the appellant in this case, Avelio Santana. There are 2 issues pending before this court. One, whether Santana's constitutional rights were violated when the trial court made the different occasions determination rather than a jury. And 2, whether the trial court erred in finding that Santana's 2 robberies occurred on different occasions. This court need not reach the second issue, and may and should remand to the district court based on the United States Supreme Court's decision in Erlinger versus the United States. For over 25 years, the law in this circuit was very clear, and it allowed the district court to make the different occasions finding for the purposes of the Armed Career Criminal Act. It allowed the trial court to determine as a sentencing issue whether the defendant committed 3 or more violent felonies on occasions that were different than one another. After Santana had been sentenced, and while his appeal was pending before this court, the United States Supreme Court overturned that long-standing precedent in this circuit on who the fact finder should be on the different occasions issue and what the standard of proof should be. The U.S. Supreme Court decided that that determination must be made by a jury and must be made upon proof beyond a reasonable doubt. In the district court, Santana pled guilty to being a felon in possession of a firearm, but he consistently challenged whether or not he was eligible for the Armed Career Criminal Act enhancement. He consistently challenged whether his 2 robbery convictions from 2001 occurred on occasions different than one another.
So he clearly challenged those, Ms. Turner. I guess one of the problems that I have that I hope you can help me with is why we should not treat the judge versus jury question as waived or even as an invited error based on the exchange that you and the prosecutor had with the district judge.
And so if I'm understanding the court's question, the question is, why hasn't this issue been waived? And there's 2 reasons why this issue has not been waived. One, waiver is the intentional relinquishment of a known right. Okay, and at the time, the right to a jury trial on this different occasions issue was not a known right. The
Well,
law,
the issue was clearly teed up by the Wooden opinion, correct?
in a sense, yes, it was teed up.
It was in play.
Yes. However, at the time, this court continued to maintain its precedent, saying this is what the law of the circuit is. This is a sentencing issue for the court to determine. And so, just prior to Mr. Santana's case, the Cameron Johnson case was also facing the same issue. And in that particular case, it was very, very similar, where the defense counsel had argued this is, an issue for the jury. The government agreed this is an issue for the jury, but the chief judge in that district said, this is what the law is in this circuit. And the Seventh Circuit has said, we're not going to revisit this issue unless and until the Supreme Court overturns Melendez-Torres.
Right, I get all that, but we ordinarily expect people who are unhappy with current circuit law to at least raise the issue and challenge it and preserve it for future. And that doesn't seem to have happened here regarding the choice between judge and jury. I would have thought your best response would be to say that there was nothing explicit about the standard of proof in the exchange you had with the district judge. Or maybe I missed something.
Well, there wasn't a whole lot of exchange between defense counsel and the district judge in terms of who the fact finder should be and what the defense's position should be. So the government raised the issue and said, Your Honor, we believe that the law should be that this is a jury determination. And defense counsel didn't object. Defense counsel simply was asked by the trial judge, is this what the law says? Is this what this Cameron Johnson opinion says? And defense counsel said, yes, this is what the law is. But during the initial hearing, there was some agreement between the parties in terms of this is a problem. Because defense counsel says at the initial hearing, we are looking for guidance from the court. We are trying to figure out how do we litigate this ACCA issue. So there is some agreement between the parties, and the record does reflect that this is an issue in terms of who the fact finder should be. And so...
Was there explicit discussion about the standard of proof?
There was not an explicit discussion about the standard of proof. The record does not reflect that there was ever a discussion of, is this by preponderance, is this by beyond a reasonable doubt?
If, Ms. Turner, if we were to agree with you that there was an Erlinger error here, try to say that clearly, but not waived, that was not waived, but that's preserved, what do you think the remedy would be? And I'd ask you particularly, there's been some discussion in the briefs about double jeopardy.
I believe that the remedy should be that this court should simply remand to the district court. I don't believe that the issue...
Remand for? What?
Resentencing.
And do you think we should say anything about the different occasion issue? Other than that there was an Erlinger error?
I don't think that the court needs to say anything other than that, other than this is an Erlinger issue and we need to remand back to the district court for resentencing.
What argument do you have based on what law that double jeopardy would attach? Make that argument right now. Pretend I'm the district judge.
Oh, boy.
I just don't see one. That's why I asked, what is your double jeopardy argument?
Sure. So, Your Honor, there was evidence submitted to the district court by the government and as well by defense counsel saying these are the documents that the court should consider. And the court did a very detailed analysis of what the documents were. And it was more than just a typical Shepard documents that were agreed to by both parties for the court to consider. So we're talking about the probable cause affidavit. We're talking about police reports. We're talking about other evidence, factual issues that the trial court made a determination on, that the trial court clearly considered and made a factual determination.
And why couldn't the government on remand present those same documents and arguments and evidence to a jury?
Well, I think there could be some issues in terms of the rules of evidence and what's going to be allowed in front of a jury versus what's being allowed in front of the judge. So
but that doesn't prevent the government from trying.
Well, sure.
Double jeopardy would prevent the government from trying.
Yes, that is true. And so I guess my point is, because the trial judge considered all of these factual issues, the same issues that would be looked at by the jury, that's where the double jeopardy issue comes in, because this was more than just...
But he found sufficient proof. You've got the Supreme Court in Monge against California said, apart from a capital case, we're just not applying double jeopardy in the sentencing context to these sorts of determinations. And here it would just be a trial error, right? The wrong fact finder, wrong standard of proof. And double jeopardy doesn't bar a retrial that would cure those things. We may or may not have to grapple with this, but like Judge Kirsch, if we'd like to hear what you have to say about it.
Sure.
But I don't take your briefs to be saying that we need to give the parties an answer on the double jeopardy, and that's not your ask now, is it? If I'm
That's
understanding
correct.
correctly.
That's correct, Your Honor.
Okay.
But I do think that there could be some double jeopardy issues. But what has happened previously, particularly in the Erlinger case and in the Cameron Johnson case, this court simply remanded, and the government was given the option.
Yeah, but if we do that, here's what happens, right? It gets remanded, gets tried to a jury, the jury finds the defendant, let's say the jury finds the defendant separate occasions, and you appeal and argue double jeopardy. And we were silent on it the first time around, here we are again,
Sure.
a year from now, right?
Sure.
And it will be the same three of us.
Right, so if it's clear, why wouldn't we just deal with it right now?
Let me ask you another question, although you're into your rebuttal time. You mentioned the Shepard documents and that there were more, because Erlinger also talked about Shepard and said, warned that a lot of those documents are prone to error, sometimes untested, often inessential. That's a quote from Erlinger. So I was curious, and you say there are facts here from non-Shepard documents that the court was reviewing, because I was wondering, why did you not raise a Shepard issue?
I didn't raise a Shepard issue because I was in agreement with the documents that the court should consider.
Okay.
And with that, I will reserve my 50 seconds. Thank you.
Thank you, Ms. Turner. Okay, Mr. Clark.
Thank you, Your Honor. Colin Clark on behalf of the United States. I wanted to just begin with Judge Jackson-Akumi's point. It's that if you look at, I believe it's pages 9 through 11 of the defense sentencing memo, the narrative about what happened between those two robberies is very similar to what we have argued, and so that's not a Shepard document, even though she's asserting what facts actually happened. In this case, the facts really aren't at issue. People aren't objecting to what should and should not be considered under Shepard, and so because of that, the Shepard issues, although they could have been raised, have not, were not, and we're not raising them either. We believe that this case really falls as to whether it's controlled by Richardson or Johnson, and we think it's controlled by Richardson for about 4 points. The first point, time and location. As the district court put it, the two robberies were an automobile drive away from each other. Compare that to Johnson, where the crimes occurred 0.6 miles away and approximately 5 minutes apart. Mr. Johnson, although he did use a car, could have run 8-minute miles and made it from one to the other on foot. And Judge Ripple, in a concurring opinion, really talks about the idea that of what a contiguous location looks like and why that's important in terms of time and location. And here we just don't have that. It's much more like Richardson in that sense. Second, there's no common plan. Again, looking at things like the Marion County affidavit, we have a discussion between Mr. Santana and his co-defendant in the 96th Street shell robbery that they're going to go up there and talking about the robbery beforehand. And then you have casing, you have an inside man, you have disguises and stealing a vehicle. You have all of this preparation for the 96th Street shell robbery, and then no planning, no casing, no inside man, no nothing.
Different motivation.
Different motivation. As Mr. Santana says himself, because the inside man wasn't there and he was pretty sure he was going to get caught, he might as well get more money. I mean, he only got, $250 from the first robbery, and so they went ahead and robbed the second one.
Mr. Clark, are you trying to argue here that there was sufficient evidence to find different occasions, or that it was so clear that any Erlinger error was harmless?
We made both arguments. Mm-hmm. The lead argument is de novo review, and so we're saying that they're just different occasions. And in terms of what the burden of proof would be, we argued it could all be under the reasonable probability standard, whether it's substantial prejudice, and then we also argued that it would be harmless under prong 4 of plain error review. And so we basically made we think we're correct under every standard of review.
Okay, well, I don't, but at least on the harmless beyond a reasonable doubt here. But
And we thought that particularly because there are no issues of credibility, there's no issues of fact. This is essentially a pure question of law, applying the law to the facts. And so we understand that juries are going to come to different decisions, but we would expect them to come to the same decision on the same facts in a given case, because this is an objective test.
Are you ignoring a part of Richardson that said it was a close call, where two crimes are committed on two separate occasions, where the robberies, like here, had similar victims, perpetrators, methodologies, but were separated by more than an hour and 12 miles. So if in Richardson we said it was a close call, how can you confidently say here we've got beyond a reasonable doubt?
Well, there seemed to be a common scheme in Richardson and Johnson. We're just, let's rob as many convenience stores or people at bus stops as we want. And here we don't have that. And so we have no common plan. We also have the cases occurring in different counties. And so as a matter of state law, these are treated as different occasions that must be tried in different courts. And so those two factors support the government's position compared to both cases. And
that would be true if they had just crossed the street, crossed 96th Street, right?
That is true, but the strength of that fact would then go to location and timing. And so it's not that that's irrelevant, it's just that that's a different element of the test.
Can I ask you, Mr. Clark, we remanded Erlinger, and as I understand it, the U.S. has dropped the ACCA allegation in that case, is that right? And
Yes.
were there others that have been remanded on Erlinger issues where you all have just decided not to pursue it further?
I don't know of any other case. I can tell you in that case, we did not agree that there was a double jeopardy problem. We decided, my recollection is based on all the circumstances in the case, we just decided not to retry Mr. Erlinger. And I will note in that case, he was tried by information and the 3 predicate offenses weren't listed in the information, unlike here. And in here, we also had 924E cited in the superseding indictment, and that wasn't true in the Erlinger case as well. And so it's not that.
It was messier.
It was a messier case. It's
Okay.
honestly is a much messier case.
Okay.
And here we have defense counsel conceding that the evidence is overwhelming on the 922G issue. And so we just don't have the problems of proof at all either that we might have in another case. So
Can I ask you to address the waiver issue, and in particular, I mean, if I'd been the district judge and, well, I understand why he did what he did. You were asking him to anticipate Erlinger. The defense counsel said, here's what the law is. But as to who's the decision maker, but was there any explicit waiver regarding the appropriate standard of proof?
I was trying to flip furiously through the change of plea hearing before I got up here. I couldn't find the page that discusses beyond a reasonable doubt, but typically you are, during a colloquy, you discuss the burden of proof that would occur at a jury trial.
Of course. I'm
And
not
so-
talking about that. I'm talking about the exchanges that supported your waiver argument concerning the Erlinger issue.
And we would say that one would necessarily follow the other. If you decide that you want a jury,
But then what that argument tells me, there was nothing explicit about the standard of proof. Is that right?
no,
Correct?
I'm sorry, I should answer it directly. No, and I will say that if you look at the Bro case might suggest that we get waiver on the one part and forfeiture on the burden of proof issue, because in that case, after Apprendi, the defendant did concede the judge-jury issue, and then the other issue was deemed forfeited. So I think that we might have to deal with it under forfeiture, thinking through that
Okay.
case.
Thank you. That makes sense to me. So,
Yeah, otherwise we'd have to extrapolate, right, from the discussion of a jury, that jury equals beyond a reasonable doubt. And here, the district judge did not make findings beyond a reasonable doubt.
Right, and we always argue that it was waived or at least forfeited, and so perhaps forfeiture is the better.
And then your argument would be under the fourth Alano factor that there's essentially harmless error here because the jury would conclude beyond a reasonable doubt that the robberies were committed on separate occasions if properly instructed.
We made the argument that it should be under the third prong, a reasonable probability that he would have been acquitted under Greer. But this court in dicta has over and over again said that that is not correct. Now, all of those cases were pre-Greer, I suppose, and Greer did deal with an issue in an indictment. But we made that argument, and this court has always decided in dicta that that's not the case. And the one case that did seem to follow it is just factually quite different. It dealt with a guy who had pled guilty to a mail fraud with a statutory maximum of 5 years, and he was sentenced to 260 some odd months. And this court said, of course, there's substantial prejudice there, and it cited CF, this line of cases that assumed under Apprendi it's not a reasonable probability of acquittal, but we think that Greer is the better standard. But if not, harmless error. No matter what, this court would have to deal with it under harmless error. And the one other thing that I want to say that distinguishes both this case from both Richardson and Johnson is the opportunity to stop. In this case, we have Santana an admission, which, even if, regardless of whether this is a Shepard document or not, we have him admitting that he decided to go, that he would commit the second robbery, and we have him turning anew again, and that goes to the purpose of the statute. The purpose of the statute in 1988 was to reduce recidivism, and we think that the fact that with cool blood, the fact that he decided to commit a second crime, and that there's direct evidence of that, makes this case quite different from both Richardson and Johnson, and for all of those reasons, we think this court should affirm.
Okay, thank you, Mr. Clark. Ms. Turner, do you have anything else?
Yes, very briefly, Your Honors. I just wanted to respond to the government's argument that the government believes that the jury should come to the same conclusion because the facts were the same as what was presented to the trial judge. The government ignores the fact that even though these two robberies happened in two different counties, both of those trial judges ran those sentences concurrently, which indicates that those trial judges, two different trial judges, found that this was an episode of this was a crime spree, an episode of criminal conduct. So we've got two state court judges saying this is one episode, but then we've got one federal district court saying...
Would that be admissible in front of a jury?
I think it would be. Yes, I think it absolutely would be. There was discussion in the sentencing hearings in both of those counties. The sentencing abstract indicates that they're both running concurrently. So yes, I do believe that information would have been in front of the jury.
I remember wondering during the oral argument in this court in Erlinger how on earth one should ask a jury to decide these issues. I know Judge Jackson-Acumi remembered that.
I remember that.
And I'm trying to imagine telling prospective jurors what we're about to ask them to do, but that's what Erlinger tells us to do. So we'll do our best.
Thank you, Your Honors.
Thank you, Ms. Turner. Okay, the case will be taken under advisement. Our third case is Christman versus Dudek, appeal number 24-1898. Mr. Duncan, whenever you're ready.
May it please the court, Dana Duncan on behalf of Darlene Christman, who is representing her granddaughter, NRC. We're presenting one issue today, which is whether significant evidence was adequately met that burden of proof by the ALJ, and whether there's evidence ignored were not properly or fully evaluated that contradicts the ALJ's decision. In Gadatis, this court, just 4 years ago, the last line of the decision notes, this is not a case where an ALJ ignored evidence contrary to conclusions. Well, the opposite is the case in this particular matter. The ALJ outlined, for example, in his decision, Chrisman's testimony at hearing. It's on the appendix, page 8, paragraph 1. But failed to note all of her testimony about use of a diaper, defecating in the house, urinating in the house, having defiant behavior. None of that is in the decision itself. The only point that the judge even acknowledges any of this and these problems are on what is on appendix page 12, the first paragraph. She had regressed from being fully potty trained. No explanation.
How old was the child at this time?
I believe 5, if not 6. May have been over this course of time the child was going 5 to 6.
Time of the hearing?
I think 6. I think she'd passed from 5 to 6. So, and Your Honor, that's part of the problem with this case. The standard of review under the Social Security rulings is conduct or behavior typical to other children of similar age. That's one of the main considerations. I mean, how many times have you seen a child in preschool have these problems and not have anything in here? This is not a situation.
I thought that the ALJ did consider the incaprices and the, her defiance, how defiant she was. But then noted that the skills coach was saying she was improving because of the medication and because of the skills coach.
Okay,
so why wouldn't that be enough?
Because even the judge or the ALJ acknowledged that she was regressing. So it was never completely resolved. Even the improvement was not enough. She was still doing it and still behaving in that way.
So then are you asking us to weigh? Are you saying she did but just not enough, which would seem to be not our role then?
No, it's not a reweighing. It's whether or not the judge actually considered this additional evidence. And a brief statement that she seemed to be improving is not enough for this court to trace the path of reasoning. Because there's a ton of evidence that was not considered. Not to mention the fact, which is the second part, is how many preschoolers have to have an aide stand with them throughout the day in order to make sure she does use the bathroom and does her schoolwork and is not disruptive in the class. And that never was mentioned, except that on page 12 of the appendix, the claimant is showing improvement with a skills coach. What improvement? What in this record shows that, or what in the decision evidences that there's improvement in her overall behavior? It's just, to me, it's problematic that the ALJ has basically cherry-picked evidence and failed to consider significant evidence, that being both the skills coach and the fact that this child could not or was not operating within normal confines because of the urination and defecation problem. So I guess the point is there's a balancing test that has to be weighed in whenever you're doing these cases as to whether there's sufficient evidence to show that the ALJ properly considered everything. Now, one of the things that was clear is the ALJ relied on the state agency assessment, except that when you read the state agency assessments, they never considered any of this. There's nothing in their notes in their evaluations on the disability determination explanation, it says that they considered her problems with urination and defecation, or that they considered her needing to have a skills coach. As a result, there's an evidentiary gap. And when the evidentiary gap is so large, as in this particular case, that no longer becomes a reweighing, but becomes instead a matter of whether or not there's enough evidence to show that the judge properly evaluated and considered all evidence. If there are no further questions, I'll reserve for rebuttal.
Thank you, Mr. Duncan. Okay, Ms. Schwartz, we'll hear from you.
Good morning, Your Honors. My name is Allison Talbert Schwartz, and I represent the Acting Commissioner of Social Security. I'm going to start with the three main inaccuracies that appellant has mentioned up here in his argument. The first one is that the child was 6 years old during the period under consideration. That is inaccurate. She was, during the beginning of the period under consideration, she was 3. During the bulk of the period under consideration, she was 4, and she turned 5 just shortly before the administrative law judge hearing. So the comparison point is to other children who are at that age. The second inaccuracy I'd like to point out is appellant's argument that the claimant, although recognizing that she had some limitations, was not with a skills coach all day at school. That is inaccurate. The record states that the skills coach met with the claimant 3 times a week for about an hour and a half and came to the house once a week for about an hour and met with the grandmother. The third thing that I want to point out is the inaccuracy of what the appellant said with regard to the state agency psychologist. The state agency psychologists, both of whom reviewed the record and found the same limitations that the ALJ did, indeed considered the potty training limitations. It's stated right there in their report, right under their finding, that claimant had less than marked limitations in the area of caring for herself. With regard to the skills coach, when you look at the evidence that the state agency consultants considered, all of the treatment records from the Bowen Health Center, where the skills coach was dispatched from, are among the records that the state agency psychologist considered in coming up with the same limitations that the ALJ did. Now, claimant has the burden of proving that she has marked limitations in 2 domains, and here she did not meet that burden. The ALJ had a medical opinion that she relied upon that supported her conclusion, in addition to all the evidence that she considered. What claimant is doing is using a lay interpretation of the domains and arguing that potty training difficulties coupled with work with the skills coach automatically rises to the level of marked limitations. And there is no case law, there's no medical opinion in the record suggesting that that is the case. I'd also like to point out that a plain reading of the ALJ's decision shows that she did in fact adequately consider the evidence. Turning first to the encoparesis, the ALJ considered Ms. Chrisman's testimony, that's the claimant's grandmother, that she had problems defecating appropriately. Did she cite every piece of testimony that Ms. Chrisman stated at the hearing? No, the ALJ is not required to do that. A plain reading of the summary, which is acceptable under Warnell and Gadatis, calls for summaries of this sort. In addition, the ALJ considered the fact that the encoparesis stemmed from claimant's trauma In fact, the ALJ noted claimant's reports to her therapist that she had a monster who had told her to poop. The ALJ considered claimant's treatment with her primary care physician. The ALJ also considered claimant's treatment with the skills coach, showing that at school, claimant eventually learned to use the restroom on her own and did so when asked without any hesitation. And most importantly, the ALJ considered claimant's work with a GI nurse practitioner as well as a GI physical therapist. And at the end of the treatment record, those notes show that while claimant still continued to have some accidents, as a typical 4 and 5-year-old, she was improving with treatment. And the ALJ indeed found that there was a limitation here, but compared to other 4-year-olds, the ALJ reasonably concluded that it did not rise to the level of marked. With regard to the skills coach, appellant notes that the ALJ did not recognize any improvement with the skills coach, but that is also inaccurate. In the ALJ's decision on page 34, there's ample evidence showing note after note after note of claimant's work with the skills coach in school, showing that while she was defiant and did need to be redirected at times, she did improve, and she, paid attention, and she completed puzzles, and she did what was asked. And again, in this area, there were some limitations, but the ALJ, reasonably relying on the state agency psychologist, as well as the medical record itself, reasonably concluded that claimant's limitations did not rise to the marked level. If this court has no other questions, I would recommend that the court affirm the ALJ's decision because substantial evidence supported it.
Thank you, Ms. Schwartz.
Thank you.
Mr. Duncan.
Thank you. Government misstates the law, which is, I'm not here to prove that she has 2 marked limitations. I'm here to establish that there's evidence that was not properly and fully considered and evaluated by the ALJ. It's not this court's responsibility to make that determination of whether there's marked limitations. I'm asking that the matter be sent back for full evaluation.
Is there any medical opinion to the effect that the criteria are satisfied here?
No, there was only 2. The state agency opinion was early in the process and there was no other opinion. There was one opinion that was done by a consultative examiner that only dealt with her cognitive limitations, never addressed the remaining medical issues. And as far as what the skills aide said, this decision was written in June of 22, with the hearing date being I'm not finding it offhand. March of 2021. Or excuse me, that was the thing.
March was the application.
Yeah, April of 2022. July of 2021, the record shows on page 529 and 530 that she was still having accidents in her pants and was going poop, even then rubbing it on grandma's bed. On July 19th, she used the term monster again and ended up having an accident. On September 21st, she needed direction within the classroom to stay in her chair and to continue, page 473. On September 24th, she had to be redirected because of behavior within the situation. She was again having incontinence issues. And then on November 17th, she would close her eyes and move around, and the teacher noted that she was not listening, not interacting, and needed to have additional. Not to mention the fact that the grandmother's testimony was that she couldn't even take her to the daycare or the preschool when she had a broken leg because it was required that she be there almost continuously to help supervise the child. So it's a matter of whether or not there's sufficient evidence or the evidence has been properly evaluated. And I would urge the court to make that finding that that there is significant evidence that was not properly or fully evaluated.
Okay, thank you, Mr. Duncan. The case will be taken under advisement. Our next case for argument today is United States versus Johnson, 24-2027. Okay, Ms. Eisenman, whenever you're ready.
May it please the court, Vanessa Eisenman for Artez Johnson. The district court erred in admitting Traylor's highly prejudicial other acts evidence under Rule 404B because Johnson did not actually dispute intent at trial. As an initial matter, the district court unambiguously employed the wrong legal standard when it analyzed the government's pretrial 404B motion to admit this evidence. The government used the correct standard in its motion, but the court, for reasons unknown, went back to the four-factor test that predated Gomez, which was this court's en banc decision, saying essentially that that four-factor test should be abandoned, that it was no longer useful because it led to too many automatic admissions. So that was the first problem here, and that led to the court in its analysis, which starts at Appendix 8 in our opening brief, not really realizing what was at stake here. And that's some of the things that this court in Miller and then Gomez really touched on, which is that you have to use special caution with intent evidence, and you really need to be careful about it.
Of course.
Yeah.
But one of the things, how much is meth going for in this community?
Trying to recall the trial testimony. I believe at the end they were saying, you know, it was what Traylor testified to was like maybe 2 pounds. It was like $3,000, $3,500. Maybe the government can correct me if I'm wrong.
Okay. The idea that 331 grams was for personal use was implausible.
I completely agree with that.
But that was his defense up until trial, right?
That was his pretrial brief, yes, that he had filed.
And that was what was in front of the judge when he was dealing with the government's motion in limine, right?
That's true.
Okay. When did it become clear that the defendant was not pursuing that any longer?
Yeah, at trial.
When exactly at trial?
In opening statements, in the cross-examination of the first police officers before Traylor testified, that was clear. And that was the court's duty to reevaluate that, because this court has said over and over again, it's not what matters. Pre-trial, it's a motion in limine. It's a preliminary ruling.
Right, it's not final.
Right.
And so what did the defense do to ask the judge to reconsider in light of the changed defense strategy?
Didn't do that, and we conceded that in our brief, that they didn't bring it up again. But as this court said in Morgan, that just means if we're looking at that ruling and not looking at the fact that the judge had the absolute wrong legal standard even pre-trial, if we're just looking at that, that at most means we're under plain error standard.
What was the point of Mr. Johnson's aunt's testimony?
She testified that he had been a
drug user and never sold drugs.
Yes.
I mean,
First of all, that testimony came well after Traylor's testimony. So if you want to look at that, then let's look at the defense's testimony.
So your point is the district judge should have just, I guess, I mean, before the defendant put on any defense, just guessed that that was not going to be his defense?
No.
That he was not going to make an intent?
No, that's
So how
exactly,
should the
that's
judge?
not at all what I'm saying.
All right, so the motion, government makes its motion to eliminate, the judge grants the motion to eliminate and permits the testimony.
With legal error, yes.
Okay, well, let's hold off on that for a second. Then we have opening statement, right? And then the government puts on its case in chief. And when, during that process, before Traylor's testimony, the defendants say, Judge, this testimony is irrelevant because X.
As I just said to Judge Hamilton, the defense counsel did not say that.
So
We are
so what is the judge supposed to do?
If I can answer that,
Yeah, go
yes. It would be after those two detectives testified, Traylor was going to be brought up. Everybody, it was clear that Traylor's testimony was all about 404B, right? That's
Right.
what the government raised pre-trial. That's the entire purpose of the motion. That's why it's important that there was legal error here, because Gomez says it's the judge's duty to have special concern with this. It's the judge's duty to reevaluate this based on the evidence. That's exactly what the court did in...
Wait,
Can I-
wait, no, let me ask you a question. What would defense counsel's reaction be at trial if the judge said, defense counsel, we're in the middle of the government's presentation, you come up here right now and you tell me exactly what your defense theory is going to be? Because I have to decide whether to admit this 404B evidence.
No, it's
I mean, that's-
exactly, no. What the court did in Miller is exactly what this court should have done here. And that was, okay, we're going to have this 404B testimony. I have listened to the opening and I've listened to cross-examination of the two witnesses. I do not find that intent is squarely at issue, which is what I need to find to admit this evidence, which the general rule is does not come in. So this cannot come in at this time. Government, continue with your case. This Traylor testimony can be rebuttal evidence if it does become clear that intent is put at issue. But at this point, intent has not been disputed. Therefore, this is highly prejudicial evidence that needs to be excluded.
Let me ask you about this train of thought. I get that Mr. Johnson ultimately was not going to dispute intent. He was going to make it about, I didn't possess it, the other passenger did. Does that mean intent is not at issue when the government still needs to prove intent to the jury to prove its case beyond a reasonable doubt?
Yeah,
what would be wrong with that line of thinking?
That's exactly what the court took up in Miller and in Gomez. And it said that part of the problem with this four-factor test, right, was that there was too much of this language that intent is automatically at issue, especially with specific intent crimes. And they said, if you read that, take that language to its extent, it means that intent, anytime the government has to prove intent, you can get any 404B evidence in that you want, as long as you say intent. And the court in Gomez and Miller and then in Gomez said that that's not enough because that would swallow the entire 404B prohibition against this type of evidence, and said that in order for it to be there, it has to be something more than just the government having its burden of proof. If it were enough for the defendant just to say, I'm putting the government to its burden of proof, it's a clear statement in Gomez that that is not enough to allow the 404B evidence because that would swallow the entire rule. Rather, if you look at cases like Chapman and Miller, it has to be clear that that's what the defendant is disputing. And if it's not clear, that evidence does not get to come in.
Ms. Eisman, would you agree that if the defendant had persisted, for example, in opening statements, in denying intent to distribute, claiming only personal use, that this would be evidence the district judge could exercise his discretion properly to allow?
Yes.
Okay, then the problem that I have is, in essence, presented by the plain error standard of review here, and I'm echoing what Judge Kirsch was asking about. What's the district judge supposed to do when the defense has made very clear before trial, this is going to be our theory, intent is going to be at issue, and when there is no explicit change of direction from the defense?
Mm-hmm. I understand that, and that's why we're under the plain error standard. But you can just look at what this court said in Morgan. In Morgan, there wasn't even an objection to the pretrial 404B motion. And this court still looked at it under plain error and said, what we're looking at is not you know, we're not looking at the trial judge per se. We're looking at, was this a plain error that affected his rights? And what we're looking at in terms of whether it's a plain error, is it clear that this evidence should have been excluded? And I argue under Miller and Chapman, those cases made it clear that if intent is not at issue, this evidence should have been excluded or at least should have been sidelined.
That's correct.
And
But,
then affecting his
counsel,
substantial rights.
But, please listen. I agree with your general statement of law. The problem is, how does the judge know whether the issues have changed when the defense doesn't tell him?
Because he's listened to the opening statements, he's listened to the cross-examination, and he hasn't heard intent, he hasn't heard personal use, he has heard cross-examination regarding forensics, regarding whether there was DNA evidence that Mr. Johnson had ever touched the bag. That's not consistent
The
with an
defendant
intent
doesn't even have to
defense.
give an opening statement. I mean, what you're suggesting is the judge has to listen and parse the defendant's opening statement and pull out the defendant's theory. The defendant could say, I'm not going to give an opening statement. Defendant doesn't have to conduct cross-examination. The government has to prove its case. The burden that you want us to put on the district judge is overwhelming.
I disagree.
I know you do.
This was a 404B issue that was raised pre-trial. Everybody knew that this witness, the sole purpose of this witness was to give 404B evidence, which is disfavored. It's the government's burden to prove that there's some non-propensity reason to have that. And
Correct,
this court
but you
is
just
setting-
agreed with me a few minutes ago that as long as the personal use defense was on the table, this could properly be admitted.
If he was arguing intent and not arguing possession, or just if he was arguing intent that there was no intent, then we're under Morgan. And then I concede that this case is not the same. But we're not there. He wasn't arguing intent. I did even a control F on the transcript. It's nowhere that the defense counsel is arguing intent and is arguing personal use. He's arguing that he was on drugs at the time, so you couldn't take his admission seriously, and there was no evidence that he ever touched these bags. That is not an intent defense. I'm sorry, I'm over my time.
All right, thank you, Ms. Eisenman. Mr. Canestra.
May it please the court. Good morning, Your Honors. Jeff Kinstra on behalf of the United States. The district court didn't abuse its discretion in admitting the evidence in question, and the defendant can't overcome the standard of review given his failure to raise his appellate arguments in the district court. Now, as to Rule 404B itself, the defendant doesn't even dispute on appeal that the evidence in question is relevant to intent through a propensity-free chain of reasoning. His argument is only that intent itself is not relevant, and when it comes to Rule 404B, that's incorrect as a matter of law. What determines relevance is the indictment. The indictment establishes the offenses and the elements of those offenses. The intent to distribute is an element, and therefore evidence that in fact establishes intent through a propensity-free chain of reasoning is relevant and passes through Rule 404B, which then of course brings us to Rule 403, which I think is where most of the discussion was this morning. And that is where it properly comes into play whether the non-propensity purpose is in fact in dispute. Now, intent was in fact in dispute, and it was challenged at every stage of this case, including in the matters that were before the district court when it ruled on the order in limine and at trial itself. Now, there were three things before the court when it ruled on the motion in limine. Those were the defendant's interview, in which he told officers that the drugs were his, but he intended to use them. Second was the defendant's trial brief, where he again said his defense was that the drugs were possessed for personal use. And then third is that in response to the government's motion, which asserted that the intent would be the key and perhaps only disputed issue at trial, the defendant said nothing in response. And so in fact, the district court noted on page 4 of its order that the defendant didn't dispute or deny that intent was a central issue in the case. So given that that was what was before the district court when it ruled, the district court was perfectly within its discretion to proceed on that understanding. And nothing happened at trial that should have alerted the district court to anything else, because nothing was different at trial. Now, beginning on the morning of trial, the same day that this witness testified, the defendant submitted to the district court a jury instruction on the lesser included offense of intent of simple possession. Now, the only difference between that and the charged offense is the element of intent to distribute. So again, on the very morning of trial, the same day this witness testified, the defendant is again clearly conveying to the district court intent is at issue. The 404B evidence was raised multiple times that morning, including before jury selection, again before openings. The government said it was going to refer to this evidence. Defense counsel agreed that he had no objection to the limiting instruction, and agreed to request that instruction when he wanted it to be given. During the defendant's opening statement, he told the jury, you are going to hear evidence from this cooperating witness. You're going to hear that person's testimony. You're going to hear that that person is facing their own legal issues. The defendant didn't use magic words. He didn't say intent, but he said the jury was going to hear that the defendant himself was a heavy user of drugs. He had a severe addiction. He also said the defendant was going to testify, but didn't say what that testimony was going to be, naturally. During the defendant's cross-examination of the government's witnesses, he did elicit testimony about intent. He elicited testimony that there were not signs of drug dealing in the defendant's car other than the methamphetamine itself, but that there were signs of drug use in the car. Specifically, that there were not large amounts of money, scales, packaging materials, cutting agents, things of those sorts. But there was a syringe as well as Narcan in the car, all of which supported the defendant's claim in his own interview, his recorded interview, which the jury heard, that he was going to use this large amount of drugs and that he was capable of doing so. During the defendant's case in chief, he called his aunt, the sole purpose of which was to say that he was a heavy user of drugs, but was not a dealer. And perhaps most notably, during the defendant's own testimony, he again admitted possession. Now, he attempted to walk back the quantity, but he still admitted to possessing a portion of the drugs. So if intent truly weren't at issue, then there would have been nothing left for defense counsel to do during closing arguments except to say that the jury should find the defendant guilty of possession with intent to distribute, but perhaps find that the quantity was less than 50 grams. And that's certainly not what counsel did. That would have been a short-sighted strategy because it would have guaranteed a conviction. The defendant still would have been a career offender, would have been facing a very significant sentence. And so really intent was at issue throughout the proceedings, both when the district court ruled on the order in limine, as well as at trial, even if the defendant didn't say any magic words. And really, in a case like this, where the offense is possession with intent to distribute, the defendant in an interview after his arrest has admitted possession but denied intent to distribute. Intent is always going to be at issue.
You just walked us through trial. Let's get to the closing argument, the government's closing argument.
Sure.
And now I'm going to your argument about we've got a propensity-free chain of reasoning here that should calm any fears that we might have. The government said Traylor is like the defendant, in the sense that they're users and distributors. And honestly, the defendant probably likely did what Traylor did when he bought methamphetamine. He would buy and sell, but in his words, it was his opportunity to use for free. How is that not a propensity argument?
So that's addressing two things. The first is that addressing the defendant's own testimony that he was only using and not dealing as well. So Traylor, as well as the expert witness, talked about how it's very common for meth dealers to use as well. That by selling methamphetamine and using some of it, essentially that allows them to use it for free. And the second thing is that it addresses the credibility of Traylor's testimony. Of course, Traylor was subjected to vigorous cross-examination about his motives, about the lack of corroboration. And so the government was establishing how Traylor's testimony about the nature of his drug dealing and his drug use was consistent with the evidence here. That Traylor was, just as the expert testified, the drugs that Traylor distributed were consistent with that of a mid-level dealer. And that's exactly what Traylor testified. He said he bought the methamphetamine from the defendant, he would use some of it, and then distribute the rest. So the government did not argue a propensity inference to the jury. It was arguing about Traylor's testimony, which was, of course, a focus of the defense closing. It occupied multiple pages of the defense closing, saying that this is not a person who should be believed, that there's no corroboration, things along those lines. So that was an appropriate argument by the government. I'd be happy to answer any further questions if your honors have any. Otherwise, the government would ask this court to affirm.
Thank you. Okay, Ms. Eisenman, you are out of time, but would you like a minute for rebuttal if you have anything to add? Okay.
I hope I can take less than that. Cross-examination regarding drug dealing materials, that's totally consistent, not only with, it could be consistent with a defense of lack of intent, but it also could be consistent with a defense of lack of possession. If if these 300 grams of meth aren't yours, you're not going to be running around with a bunch of other drug dealing materials, scales and the like. Admitted possession, he did not admit anything regarding, the charge conduct. So that was not an admitted possession regarding the actual element of the offense.
Not
He
even
admitted-
saying I was going to get some of the methamphetamine for driving.
He said he was going to get a portion of it, a small portion of it, because he gave, it's Mr. Duckworth, this passenger, a ride, but the rest belonged to him. So in no way was that an admission that he had possessed the entire amount of drugs. And then finally, just back to Judge Jackson Aquimi's point about the government in closing, that definitely was a propensity argument, as we argued in both of our briefs. Also, the government, right thereafter, there was a jury note saying that one of the jurors had recognized the passenger, I believe it was, and said, there was a discussion about that. But in that discussion, the government admitted that the defense's entire argument was lack of possession. So that just shows that the government was aware that this was the defense, although that's at a later time than Traylor's testimony. So thank you for the extra minute.
Sure, thank you, Ms. Eisenman. And thank you, Mr. Knesh. The case will be taken under advisement. Our next case is Abayami versus Collins, appeal number 24-2943. Well, Mr. Ryan, whenever you're ready.
May it please the court. Counsel, good morning. My name is Paul Ryan, and I represent the appellant, Hakeem Abayomi, in this matter. Mr. Abayomi was a clinical pharmacist at Hines VA. He was terminated in April of 2016, and in this case, he claims that he was terminated because of his race and because he complained about discrimination involving his supervisor. The district court granted summary judgment in this matter on September 30th, 2024. We believe the district court erred, and we ask that the decision be reversed, in this case be remanded for trial. As explained in our briefs, there are significant questions of disputed material fact that justify a trial here and could lead a reasonable jury to determine that Mr. Abayomi was fired because he's black and because he complained about his supervisor. Mr. Abayomi was the only black pharmacist at Hines VA in recent memory. None of his supervisors could recall any other black clinical pharmacists working there. He was also the only clinical pharmacist that was terminated, at least as far as the chief of pharmacy, Don Links, could recall, and he had been there for several years. That's suspicious in and of itself.
What's your best argument of pretext?
The best argument
He clearly
is,
had employment issues.
he had employment issues, but numerous other pharmacists had employment issues too. As laid out in our briefs and in our local rule 56.1 statement, errors at Hines involving medication were widespread. They happened frequently, and a lot of these errors involved pharmacists who were in the same chain of command as Mr. Abayomi, and the supervisors looked the other way.
So what's the best argument that you have that the reasons that the VA gave for the termination were a lie?
Because Mr. Abayomi's, the reasons given were Mr. Abayomi's work performance. As the district court found, Mr. Abayomi established on summary judgment that his work performance met expectations. Mr. Abayomi disputed all these errors for the most part, and here there were many other employees who made similar errors and they just weren't fired. And those employees are non-black. Mr. Abayomi is black, and in addition to the fact that
So it sounds to me like what you're saying is that we should extrapolate from the initial burden to pretext, because the arguments that you've made seem to me to say that Mr. Abayomi established a prima facie case of discrimination, and from that we should extrapolate pretext. In other words, because he was the only black pharmacist and because other pharmacists who made mistakes were not fired, that not only establishes the second and fourth element of the Douglas test, but also establishes pretext in this case? Or is there more?
Well, as I mentioned in our briefs, this is the kind of case where the elements of performance and pretext overlap because they're claiming he was fired for bad work performance. He disputes that, and in fact, the district court found that he had established that his work performance met expectations. That right there presents sufficient evidence for a jury to find that the claim that these mistakes or alleged mistakes justified termination is not an honest claim. But there's more to it than that. There's also the fact that that Mr. Abayomi made this complaint of discrimination against his supervisor, and his demeanor changed immediately, and within a month of his other supervisors being notified that he had made the EEO complaint, they started reaching out to labor relations to discuss the quote-unquote case for terminating Mr. Abayomi. That kind of suspicious timing is highly suggestive of retaliation, and when they reached out to labor relations was somewhat skeptical, asking, do you have any evidence? And then suspiciously, within a day, Elizabeth Stone, the second level supervisor, conveniently discovered that there was another alleged medical error, which is very suggestive of pretext. It shows that they had made this decision to terminate Mr. Abayomi before they had the evidence to do it.
Let me ask you about Mr. Elliott. Are you not making a cat's paw argument, or are you saying that it's relevant, Elliott's bias and his input into the decision making is relevant in this total picture, and it's not a cat's paw argument? Which is it?
I would say that it is a cat's paw argument. He had an influence on the decision to terminate Mr. Abayomi. Don Links, the chief of pharmacy, acknowledged that Mr. Elliott was one of the people who made the recommendation to terminate Mr. Abayomi, and therefore he did rely on Elliott's input here.
Do you necessarily need that? If we're looking at this, holistically, as Ortiz would have us, do you need to say that you're making a cat's paw argument with Elliott, or just that Elliott is one part of this big picture of what makes what happened here suspicious from your perspective?
I think regardless of how you describe it, whether you label it as a cat's paw argument or not, it's part of the totality of the circumstances that is indicative that race was a motivation in the decision to terminate Mr. Abayomi. You have the comments from Mr. Elliott calling him boy, speaking in Ebonics, and all of that tends to suggest a discriminatory motivation for Mr. Abayomi's termination.
Mr. Ryan, from your perspective, I gather that at least some of Mr. Abayomi's mistakes are undisputed.
There was an error that Mr. Abayomi admitted to. He dispensed a insulin pen instead of a vial, but
is that the only one?
I believe that's the only error that he concedes, and there's evidence that that was a trivial and common error that was made by many pharmacists. And
what about the 5-fold heparin discrepancy?
Well, Mr. Abayomi, he does acknowledge that there was that he distributed the wrong, that he verified the wrong concentration.
Okay, so why doesn't that count as an undisputed mistake?
You're right, Your Honor. I misspoke.
Okay.
He did concede that he made that mistake, but there are other employees who made the same mistake, and we're not.
I gotta say, we see tort claims against the Department of Veterans Affairs based on medical and I assume drug mistakes as well, and this is pretty sobering. If you're telling us that the mistakes are so rampant that we should infer race discrimination from the termination here.
These are the facts. You can look at paragraphs 29 through 59 of our local Rule 56 statement. Errors are widespread, and other people have not been let go. Mr. Abiomi is the only person, the only clinical pharmacist that anybody can recall being fired from the VA. He's also the only black clinical pharmacist. Unless the court has further questions, I'll reserve the remainder of my time.
Okay, thank you. Okay, Ms. Turman.
May it please the court, counsel. Mr. Abiomi was terminated because he was suspected of making dangerous medication errors. He confirmed that he made dangerous medication errors, and then he offered a very concerning explanation for why he made the medication errors. In a Weingarten investigation at which Mr. Abiomi had union representation present, he was confronted with the suspicion that he had made these errors, and he was told, this is at Exhibit 30 of the defendant's summary judgment materials, he stated as follows: I was told to watch my numbers. This was the reason for the mistake. I was told to watch my numbers. Prior to February 12th, I never had issues. I verified the wrong stuff on April 8th. I walk on pins and needles. I was rushing to verify my orders. That related to the heparin overdosage. When confronted with another error, he said again, hindsight is 20/20. I should have changed the vial. I did a new dose for a vial, but I totally forgot to change since I was concerned about numbers. This was for sure rushing.
Is it true that that investigation was initially scheduled for April 19th, the day before the EEO mediation on April 20th? The blue brief tells us this, and I don't have a confirmation from you all.
I'm not sure about the scheduling of the mediation, Your Honor. What I do know is that Abiomi filed his EEO against his former first-line supervisor, Mr. Elliott, on March 7th. And then the Weingarten investigation was scheduled for April 19th, which responded to a cluster of medication errors that was earlier in the month of April.
And I'm asking, was that the day before the scheduled EEO mediation on April 20th?
That may have been, Your Honor. I'm not sure when the date was of the scheduled mediation. Well, we do know that the surrounding context about the timing here, and we see Mr. Abiomi referencing that he was rushing because of his numbers, is there were mounting concerns about his productivity that preceded the medication errors. The Hines VA is a A1 facility, which means it's one of the largest VA medical centers in the country. It has almost 1 million patient encounters every year. So in addition to wanting pharmacists to exercise care in their duties, there's a volume that as a group that they need to meet. Mr. Abiomi was not carrying his weight 6 months into his probationary period when he should have been catching up to productive requirements. There were concerns about that. And in an effort to rush and meet his production numbers, we see this cluster of errors, which he admits to. And with respect to the claim that other pharmacists made errors, there's no competent evidence of that in the record. The evidence that Mr. Abiomi continually cites in support of his comparator arguments are his own declaration about his coworkers. When he was on his way out after he received notice of termination, he sent an email slinging mud at his coworkers. Why weren't they terminated? And then he filed a similar declaration before the district court. It's got to take more than that to create a factual dispute of similar misconduct.
Do you, if Hammond were a proper comparator, just stick with me for a minute.
Sure.
Why would the evidence of different treatment, in addition to the timing here, not be enough for a jury to consider retaliation?
And I'm sorry, to make sure I heard you, you're referring to Patrick Hammond as a comparator? Thank
Yeah.
you. Patrick Hammond is the closest that plaintiff comes to identifying a comparator. Patrick Hammond is the only other pharmacist that there was some awareness on the part of management of an allegation that there was a medication error, rather than just Abiomi's own personal view that his coworkers weren't doing a good job. And Patrick Hammond was on a probationary status at the time of the alleged errors. So this is worthy of further consideration. So there was suspicion of medication errors that related to Patrick Hammond's work. There was then fact-finding conducted by the VA's Office of Medical Inspectors, and that's a group of clinicians that comes in and reviews the record. And this is important for the court to review. It appears at docket 48-3, exhibit 62. And the fact-finding resulted in conclusions about the way the pharmacy department operated as a whole, how it was orienting new pharmacists, how it was doing schedule changes. There were no findings related to Mr. Hammond's individual competence or judgment. There were
So
no.
Hammond was never subject to a Weingarten investigation like Abayomi.
Correct. If that report had revealed concerns about Mr. Hammond's individual competence and performance, not systemic issues and areas for improvement for the pharmacy department as a whole, then there would have been issues that would have given rise to a Weingarten investigation. He would have been confronted with what they viewed as his errors. But it
But
never.
let me make sure I understand
Sure.
you. But you're not saying Stone was not. You concede Stone was aware of errors Hammond had made, or reports of errors Hammond had made. That you're not disputing.
That's correct, Your Honor, because Stone was aware of the findings of the VA's Office of Medical Inspector. And again, there were no substantiated errors as a result of all that comprehensive fact-finding that would have served as a basis to discipline Mr. Hammond. And so why are we looking at all of this, Hammond's performance versus Abayomi's performance and the disparate fact-finding? The question is, would there be a reason to infer discrimination from the fact that one of these pharmacists was terminated and the other was not? Or is the different treatment something that flows naturally from the different circumstances? And in this case, it's the latter. There were suspicions of medication errors. The VA looked into what was the cause of those medication errors. With respect to Mr. Abayomi, it related to his individual competence and performance. And with respect to Mr. Hammond, it was found to relate to systemic issues that the pharmacy department and pharmacy management need to tackle on its own. And so there would have been no basis to terminate Mr. Hammond, and so it makes complete sense that he was not terminated. No reasonable jury could infer from that Mr. Abayomi's termination was because of his race or protected activity. I wanted to address briefly Abayomi's reference to the cat's paw theory of liability. This is effectively a concession that the decision makers involved here, Ms. Stone and Mr. Links, weren't acting with racial or discriminatory animus themselves. And indeed, there's no evidence that they were acting with racial or discriminatory animus. But because Mr. Abayomi believes he has evidence that Mr. Elliott harbored racial or retaliatory animus, and for purposes of this discussion, I'll concede that because he claims he heard this boy statement, for example. Through the cat's paw theory, Mr. Abayomi wants to show that Stone and Links were influenced by this bad actor, Mr. Elliott. But what he ignores here is that there's two elements to satisfy a cat's paw theory of Abayomi. One is the animus element, which again, for purposes of this discussion, we concede. But the second is a causation element. He has to show that Elliott, the bad actor, caused the termination. And a cat's paw theory is nullified in cases like this where the decision maker is acting in meaningful part on their own fact-finding, their own investigation, even when the bad actor puts the wheels in motion. So that's exactly what's happening here. Appellant alleges that Mr. Elliott, the bad actor, put the wheels in motion by requesting this Weingarten investigation, but then the independent fact-finding of the decision makers, principally Ms. Stone, was that these medication errors had occurred and that Mr. Abayomi explained them by saying essentially, look, I can meet my production requirements or I can act carefully. I can't do both. And in that way, the cat's paw theory of liability is nullified, and the causation requirement is something that we direct the court's attention to, and appellant's inability to satisfy that. Just one thing quickly, we heard a moment ago this idea that some of the VA's witnesses were confronted in deposition and asked to explain what other black pharmacist has ever been terminated from this group. I just want to point out that this is a disparate treatment case, not a disparate impact case. And general statistical evidence, such as accounting for the number of racial minorities in a particular position or a particular group, is an improper vehicle to prove discriminatory intent. And that comes from this court's decision in Player v. E.J. Branch, 105 F. 3rd, 343. I see I'm out of time.
You contend it's irrelevant or
I'm
just
sorry?
insufficient?
It's irrelevant to prove discriminatory intent on the part of the decision makers, and even if it was relevant, the type of evidence that Mr. Abayomi has marshaled here that he was the only black pharmacist would fall far short of what the law requires in terms of statistical methodology that we see in disparate impact type cases. And this court recently explained that statistical methodologic requirements in Downing versus Abbott Labs, 48 F 4th 793. And there the court explained that it's not just enough to show that there isn't the type of representation plaintiff would want to see in a given employment group. You have to look at the sampling, what the job market, what the type of applicants are, to see if that representation is meaningful or not. And if there are no further questions, we'd ask that this court affirm the decision below.
Thank you, Mr. Turman. Mr. Ryan, anything else?
A couple of things, Judge. One thing that the VA mentioned is that Mr. Abayomi has no evidence of similarly situated employees being treated more favorably because he's relying on his declaration. That's obviously not the case. We have the investigation into Mr. Hammond, and we also have testimony from his comparators who acknowledge that they made mistakes, such as Alex Chu, and acknowledge that they were counseled by their superiors, including Mr. Elliott. In addition, the cat's paw theory that the counsel brought up, I disagree that wouldn't apply here. There is a question of fact as to whether this was truly an independent investigation taken in good faith. Judging from the timing of the initiation of the Weingarten hearing, a reasonable jury could find that Elizabeth Stone had a retaliatory motivation against Mr. Abayomi as well. And putting the cat's paw theory aside for a second, this case can also be established just on a traditional indirect method of proving discrimination theory. The client Mr. Abayomi met the performance expectations of the VA. He was terminated. Similarly situated employees were treated more favorably. He's in a protected class, and the explanation for the termination is pretextual. So even if the cat's paw theory were unsuccessful, there's another way to find in favor of Mr. Abayomi. So unless you have any other further questions, I would ask that the district court decision be reversed and remanded for trial.
Thank you, Mr. Ryan.
Thank you.
The case be taken under advisement. Our next case is United States versus Ante, appeal number 24-2064. Mr. Geisfeld, whenever you're ready.
Excuse me. May it please the court. My name is Matthew Geisfeld, and I represent the appellant Paul Williams Ante. At sentencing, the government and Ante agreed that he did not necessarily know the particular details of the fraud scheme, and the district court thought otherwise. And it also decided it knew what knowledge it believed Ante possessed and was withholding.
Mr. Geisfeld, did the defendant disclose to the government in the course of this case who had contacted him originally and brought him into this scheme, when, how, where, how he wound up setting up all these fake bank accounts?
He disclosed his role in setting up the bank accounts.
Did he answer those questions?
No, he did not. The government...
Would those things seem to a reasonable district judge to be within his knowledge?
If the district judge is also assuming that Ante possessed that knowledge, which is exactly
Is it unreasonable to assume that the defendant would know who contacted him, when, how, and how he got those accounts set up?
It's, I think, unreasonable given the facts before the court. It's unreasonable given that the government presented no information to suggest that Ante knew these roles. The government and its factual...
What I'm asking about are things that are about his personal knowledge.
And just to clarify your question, asking if it would be reasonable for the court to assume that he, or infer that he knew those things?
That he knew how he had been contacted, when, by whom, or if it was by some anonymous source, why on earth he agreed to participate in this multi-million-dollar fraud scheme. Things that would clearly be within his own knowledge about his own role, even if he didn't claim knowledge of the larger scheme.
I think he admitted that there was some connection. Ante admitted that there was some connection. He admitted that the people that he was connected with were performing illegal activity, and he admitted that he knew that the illegal activity, or that the funds being deposited into his account.
He admitted the bare bones of the elements, right?
Yes, absolutely.
And that's it.
Yes.
What?
So I guess my problem is, and you agree there was no minor role adjustment. That was proper.
Correct.
Okay. So the government made this point in their brief, and I'd like to understand your perspective on this. But the argument in mitigation seems to have been some kind of variation on a minor role in the larger scheme without challenging the guideline calculation, but not supported by any evidence.
Your Honor, the argument was that the sentencing guidelines contemplate all roles within money laundering. And what the defense presented at sentencing was that we have evidence that Ante's role was compartmentalized.
What was that evidence?
The evidence stipulated to, the evidence that the government admitted and agreed that he didn't know how the fraud was being perpetrated. And I think the how the fraud is being perpetrated is the best comparator or distinguishing factor, Your Honor. Having contact with a person, and as Ante admitted, allowing that person to deposit what Ante knew was illegal funds is absolutely one thing. To know then how that person is perpetuating the fraud, how they got the money, that is a completely separate thing. And that is what the district court specifically said it believed Ante knew. The court said that Ante should have disclosed who he's working with, how this is arranged, and where the money ends up. Those additional factors, some connection.
Why wouldn't those things be within his knowledge, at least where he's sending the money?
The money was withdrawn from his accounts. He doesn't know where it's going.
Who's the owner of the account? How does he not know where it's going? I mean, this just seems to me to be totally incredulous. Your argument here, how would you not know where money is going when it's leaving your account?
He agreed and stipulated to that unknown fraud perpetrators, he gave access to his accounts. Absolutely, Your Honor.
And then he lost all access altogether.
Yes.
He couldn't access his own accounts.
No, he accessed his accounts. Once the money left the accounts, he no longer had access or knew where that money was.
And his claim is he did not know who had that access.
Correct. He knew he had contact with an unknown person. He knew that that was anonymous. And I think that
And why did he agree to do this with people he didn't know?
That would only speak to his state of mind, and he admitted his role in this offense and admitted culpability. Your Honor, the distinction here, I think, is that it's not necessarily a dichotomy. It's not that you know nothing or you know everything. And what the district court said is that there's no possibility that Ante could, those are the only two options. That Ante either knows nothing as sort of what he presented, although he admitted some connection to the unknown fraud perpetrators, and that he must also know everything.
That is clearly an exaggeration of the district court's thinking.
Well, I say that based upon the district court's quotes, and if I am mischaracterizing those quotes, I apologize. But the district court indicated that Ante possessed knowledge and failed to disclose who he's working with, how the fraud is arranged, and where the money ends up.
Exactly.
Yes. And so that, I guess, is my point with the dichotomy, is that
That's not all versus nothing. That's why I started by asking you about what was reasonable for the district judge to expect the defendant to know.
But would it only be... Ante's not obligated to tell the government or the district court any of that.
Absolutely.
Is it just that if Auntie wants to make an argument that my role is so discreet, please take that into account, then the judge would reasonably expect Auntie to explain.
The purpose for which the court used this extra record information doesn't matter to the procedural error.
What extra record information?
The two categories of extra record information are that Auntie both possessed knowledge about, as I've quoted to Your Honor, how access was gained to the victim's accounts and business systems to create the money that was deposited into the accounts that Auntie managed.
Yeah, he might not know that.
Right. And then the court, in justifying that expansion of Auntie's role from what the evidence actually showed, the court offered this extra record information about Ghana.
No, he didn't. That's so unfair to the district judge. Your client raised it as an excuse for his conduct. And the district judge said, wait a minute, what does this have to do with Ghana? And you raised it, or you're, I'm upset. Look, the defense counsel raised this in his sentencing memorandum. Said, oh, he's an immigrant. He doesn't know anything about the criminal justice system. And then your client says, oh, by the way, I'm from Ghana. And the district judge says, what does that have to do with anything? And then, by the way, there's no objection from defense counsel whatsoever. This is all during the allocution. The allocution ends, no objection whatsoever. None.
With regard to the objection point, Your Honor, this court has held that...
No, we have not. We've held during the allocution, after the allocution, defense counsel has got to object. That's different than the judge stating his reasons for the sentence.
Okay.
So you've got one, which is a misstatement, something along the lines of Ghana is the largest economy in Africa. He may have meant one of the largest economies in Africa. Who knows? But your client raised the Ghana issue as an excuse for his conduct. And what you're telling us is the district judge should have just sat there and ignored it.
That is not what I'm telling you, Your
Then
Honor.
what are you telling us?
However, whatever reason Mr. Auntie raised it, which he did bring it up, and the defense...
I know why he raised it. Hold on. This is, these statements of yours, he raised it, he said, the judge, how is it possible? How could you not foresee the risk of your conduct? That's why I said with my African background or Ghana background. He told the judge why he raised it.
You're right.
So we know.
Did Mr. Auntie finish his sentence there?
No,
Or
Your
any
Honor,
of those
and I
sentences?
appreciate that. I want to respond to Judge Kirsch very... we don't... What Mr. Auntie says is yes. I think it's a fair recollection or fair description of the record to say he was talking about his African descent, his native country, with regard to why he might have not understood what his limited role was. The difference, though, and what we've argued is that rejecting that idea about the connection is not the same thing as then saying, I don't believe that you don't know about the fraud. The court used the Ghana references to say that this type of fraud and money laundering is common in Ghana, and therefore, Mr. Auntie, you must know it as well. And that, we argue, was a step too far. I see my time has expired if there's any other questions.
Okay, no, thank you, Mr. Geisfeld. Ms. Oswald.
Good morning. May it please the court, counsel. The district court did not commit procedural error in this case. It did not make erroneous findings of fact. It did not rely on erroneous information. It did exactly the opposite of that. It rejected defendants' arguments for mitigation that were clearly unsupported by the record. It drew reasonable inferences based on the record and sentenced Mr. Auntie based on the things that were known, not the things that were not. And as a result, this court should affirm. I want to talk briefly about the undisputed facts because that is what framed the court's comments during sentencing. It was undisputed that Mr. Auntie was engaged in and operated a complex money laundering scheme. He used multiple fake identities, fake companies, and fake documents. He opened and controlled multiple bank accounts, at least 14 in different banks. I want to take issue with some of the representations that were made during opposing counsel's arguments. I think the court needs to look carefully at the PSR to know what the facts of this case are. I don't think that there's any evidence that some unknown fraudster was pulling money out of those accounts. What the money laundering scheme was money was coming into Mr. Ante's accounts, and he was directing it to other accounts that were controlled by him. There was no one else that the government found that was controlling those accounts or withdrawing money from those accounts. He facilitated millions of dollars in fraud proceeds being moved through and to places unknown, and again, he was funneling it between accounts himself. He used an Alzheimer patient as a front to conceal his activities, and he engaged in this behavior for several years. So in other words, he was a sophisticated money launderer. He was not a novice. He was not some low-level player.
And then he got up at sentencing and said, Judge, I don't know anything because I'm from Ghana.
Correct. And again, I think the court recognizes context matters. What all of this came about because in his sentencing memorandum, he tried to argue that he was some small bit player who retained very little of the fraud proceeds. And he made those arguments based on other cases, not this one, in which money launderers kept, I think he said the quote was, some small percentage, 4%, 2% of the proceeds. And from that, he tried to extrapolate that he had only retained $77,000 out of $3.4 million that was going through his accounts. And the court engaged in that conversation with him a little bit, but ultimately said, wait a minute, you're asking us to speculate. None of that is before the court, and so I'm not willing to go there. And that was proper for the court to do that.
Can you respond to Mr. Giesfeld's point? Mr. Ante does raise his African background. He starts to make some point. By my reading of the transcript, he is talking about not understanding the consequences of his actions, but he doesn't finish his point. The court interrupts him. Now, later on, and the court does say, as Judge Kirsch has said a flavor of, what does your being from Ghana have anything to do with it? Later, however, the court says Ghana is such a large economy, something he repeats a few times, and then says there's a lot of fraud happening there. Why are we not to read that as the court connecting Mr. Ante's being from Ghana with an inference that he must know something about fraud, a lot about fraud, something about this fraud, more about this fraud than he lets on? Can you help me there?
Yes, Your Honor. Again, context matters. So as the court has already recognized, this whole issue about him being from Ghana was raised by the defendant himself, where he said, I didn't know anything about anything. I was duped. I was misled. I didn't know. I had no awareness of these unknown people out there. I couldn't foresee the risks, dangers, and possible consequences of my conduct because of my African background. He used that term multiple times, and the court did let him explain, like, it was my African background, Your Honor, that I just didn't know anything about anything. And the court was understandably incredulous at that and said, wait a minute. What does Ghana have to do with anything? And I think the court was not saying, because you're from Ghana, which is this hotbed of fraud, you must know more about the underlying fraud and must have been involved in it.
How do you account for the court's statement? This is where I perhaps was too long of a wind-up for you. My question is, what do we make of the court's comment that a lot of fraud happens in Ghana? That specific comment.
Right, and I think that is in the context of what the defendant was trying to argue in the court, saying, wait a minute, Ghana is not some unsophisticated country where none of this stuff ever happens. It would be like saying, I didn't know the consequences of my actions because I'm from Chicago.
Well, no, it'd be like the judge saying there's a lot of drug dealing in Mexico.
Correct.
There is.
Right.
Right? I mean, would we extrapolate from that the judge sentenced a Hispanic defendant more or to a larger sentence because there's a lot of drug trafficking in Mexico?
No, and I don't think there's nothing in the record to suggest that the court relied on that information to say that somehow Mr. Ante played a bigger role or somehow knew the underlying pieces of the fraud. The court was very clear that it was sentencing him on the facts that were known. And the court even said that. The court specifically said whether or not he was involved in that underlying fraud is unknown. What is known is that he operated a very sophisticated money laundering operation, moved millions of dollars through those accounts, and all of that money is now untraceable. And so the court properly focused on what it did know and refused to be persuaded by what it did not know and what Mr. Ante did not disclose. Unless the court has further questions, the government rests on its brief and asks the court to affirm.
Okay,
Could I ask you to comment? It was not cited in the briefs, which you may be an escape hatch here. In a case called Trujillo Castillon, a district judge had made some comments during the sentencing hearing that tended to focus on the defendant's ethnicity and national origin. And a panel of our court sent it back for resentencing, in essence saying if there's reason to doubt about this sort of a sensitive issue, we ought to just send it back. If you're not familiar with the case, maybe there's not that much light to shed on it.
I'm not familiar with the case, Your Honor, but
it's 692 F. 3rd 575 and 578, just for everybody's reference.
I would be happy to submit some supplemental briefing on that, but what I would say to the court is I don't think remand is required in this case. The court clearly was not focusing on that Ghanaian background as a way of justifying its sentence. It was merely expressing skepticism about Mr. Ante's perceived or articulated ignorance of what this fraud was about, or what his unsophistication, which was just completely belied by the record in this case. He was a very sophisticated money launderer.
Thank you.
Okay, thank you, Ms. Oswald. Mr. Giesfeld, your time had expired, but would you like a minute for rebuttal?
Yes, thank you, Your Honor. Appreciate it. I'd first just like to add I appreciate the government's correction. My indication that Ante did not control the funds was based upon the PSR, that he didn't retain it. I think counsel's representation about the actual accounts is more accurate. I apologize for that. Judge Kirsch, you brought up the idea of a Mexican cartel. Simply draw the court's attention to a case, U.S. v. Smith, from this court, 400 Federal Appendix 96, in which the sentencing court referenced Hitler, Cesar Chavez, and the Mexican drug cartel, and somehow used that information and applied it to the particular defendant. That case might be illustrative here in the instance in which the court, I do agree, Judge Jackson, that the district court seemed, based upon his line, that this type of fraud exists in Ghana, and therefore, Mr. Ante, I find it hard to believe what you're telling me. He used, I think, the plain reading of the transcript indicates that he used that information to refute Ante. And with that, I yield my time. Thank you, Your Honor.
All right, thank you, Mr. Giesfeld. Our last case for argument today is United States versus Snake. Appeal number 24-2400. And Mr. Giesfeld, this is your case as well. Yes. Whenever you're ready.
May it please the court. My name is Matthew Giesfeld, and I represent Mr. Roger Snake. The district court carefully explained why it would not sentence Snake to home confinement, but it didn't specifically explain why it imposed a statutory maximum sentence that was nearly 3 times the upper end of the guidelines range. The court did not provide the required heightened explanation for this significant upward departure, and in doing so, the sentence lacked the perception of fair sentencing, a basis for sufficient appellate review, and the assurance that the court avoided unwanted sentencing disparities. And for this procedural error, Snake asked to be resentenced. Briefly to recall, Your Honors, Roger Snake was revoked from supervised release, and the guidelines called for a 3 to 9 month revocation sentence. The guidelines also said that given the type of violation and given the underlying offense, that sentence may be served on home confinement. And Snake asked the court to follow the guidelines. He asked for 3 to 9 months. He asked for the 3 to 9 months that the guidelines advise, and he asked for these months to be served on home confinement. And the sentencing court took issue with the latter. It said, allowing him to go back home makes no sense to the court. And throughout the transcript, Your Honors, the issue of home confinement bookended the court's description and back and forth with the defense. The court started by rejecting the idea of home confinement, and it ended with rejecting the idea of home confinement, and in the middle, the court explained its reasoning for why home confinement would not be the sentence that it would impose. But when it came to the length of the sentence, the court simply stated in mostly a conclusory fashion the legal standards that apply to sentencing. The court said that if the intent of its sentence was to hold the defendant accountable for his violations, protect the community, and engage in both specific and general deterrence. The only time the court mentioned the length of incarceration was when the court actually imposed it. There are heightened requirements for the explanation of a significant upward departure from the guidelines. There must be a statement of reasons for the particular sentence. That's from Baker. The court must explain why it's appropriate for the particular defendant in the case. That's from Jones. And from the United States Supreme Court, an explanation is proportionate to the deviation from the guidelines.
Would you agree that the revocation guidelines are sort of the mildest ones in the guideline system, and that our review is most deferential for those?
It is most deferential for those, Your Honor. You're right. However, this court still doesn't give deference to the sentencing court when a procedural error exists.
When, I don't know, I'm going back a few years on this, but when we saw a lot of appeals of sentences arguing so-called Cunningham errors, arguing that the district judge did not respond sufficiently to principal arguments in mitigation. This court responded to a flood of those appeals by encouraging district judges to ask defense counsel at the end of the hearing, in essence, have I sufficiently addressed your arguments, or should I say more? Did that kind of exchange happen in this hearing?
As I left my binder over there, I don't recall specifically if that occurred. The transcript would reflect that, Your Honor, and I apologize for not having that at the tip of my tongue. The court, though, the more dispositive factor, Your Honor, would be that the court just leaned into the sentencing, the length of time. It just stated the conclusory reasons.
Is it your position that the judge first has to say, I'm going to give you a sentence above the policy guideline recommendations, and here's why, as opposed to the judge saying, here are the reasons for my sentence? I mean, I don't think I've ever been in front of a district judge. I think every district judge I've ever been in front of, they say, here are the reasons for my sentence, and the sentence is X. They don't say the sentence is X. Here are the reasons for my sentence. The sentence is X.
Absolutely, Your Honor, and Snake is not suggesting that there needs to be some magic word
Well, what do you
component.
make of these comments? That he was one of the most dangerous sex offenders to children. He was intelligent enough to hide their predatory actions. I mean, what about all the... I mean, these are pretty damning statements by the district judge leading up to the 2 years.
Absolutely, Your Honor, and with that I'd respond with 2 points. First being, again, that the sentencing transcript reveals that his reasons were bookended by the topic of home confinement. That's what he was talking about. He said, I'm rejecting home confinement, here's all these reasons, and back and forth, and then he ended with, I'm rejecting home confinement.
So he had to repeat them? Is that your point? He had to then repeat the same things that he had just said in announcing a 2-year sentence?
No, Your Honor, but he needed to give some explanation to let us know as parties and for you as the court to know exactly what was his explanation for it. Those factors may have been repeated, absolutely. And maybe he could have said something like, for all these other reasons, here's why a longer sentence is appropriate. I don't think that would necessarily meet the heightened explanation requirement, but it would at least take away the ambiguity.
Do you have a case that tells us that, yes, we have the cases that review is very differential on these revocation sentences, but we also have Gall and all its progeny saying a court has to explain its sentence and the greater the departure, the greater the variance, the greater the explanation. Is there a case that marries those two standards and requirements that would tell us what the answer is here?
Yes, Your Honor. I believe Lockwood is a revocation sentence. I cited that in my opening brief. And in Lockwood, the court, this court, I believe, said at the end, the allusion to the obvious fails to prove the compelling justification Gall deems necessary to impose an above-guideline sentence of nearly 3 times the high end of the guidelines range. And that's exactly what we had here, Your Honor. Yes, the sentencing guidelines, I think to Judge Hamilton's point, maybe the revocation guidelines are milder, but they still contemplate the exact type of violations and underlying offenses that Snake had. It contemplates the type of defendant that he was, and it called for a 3 to 9 month range. And so to give him the statutory maximum, the court was saying that he's essentially the 99th percentile, that there is no more serious of an offender under these circumstances, so I'm giving the statutory max, and he didn't say why. And with that, unless there's any immediate questions, I would yield the rest of my, or reserve the rest of my time for rebuttal.
Okay, Mr. Stephen.
May it please the court, good morning. My name is Corey Steffen, and I represent the United States in this matter. The district court here adequately explained its sentence in this case. It did not procedurally err, and the sentence is not plainly unreasonable. The district court considered the advisory sentencing guideline range, had a lengthy discussion with the defendant about the court's concerns about the defendant's behavior in this case. The district court adequately explained its reasons for the upward departure throughout the record as a whole and in the summary in the end, at the end of the transcript. And the district court also stated reasons for that upward departure, citing 3553 factors, which we know are not required to be addressed in checklist form, but which the district court did address in its comments, certainly some of the 3553 factors. So the district court only has to say something about the guideline range and the sentencing factors. And here the district court found the guideline range of 3 to 9 months, asked if there were any objections, and there were none. And the record here as a whole is a thorough explanation of the district court's concerns with the defendant, specifically his behavior.
Let me ask you a question about your say something argument, because that language is from Martin, I believe, or if it's not Martin, it's still a case about the judge's failure to consider the guideline range. In that particular case, the judge did not consider the guideline range and then also didn't mention it. So the appellate court, we said, we don't even know. The judge has got to say something so that we know the judge knows what the guideline range is. But that doesn't appear to be Mr. Snake's argument here. His argument is we've got a line of cases that also say you have to adequately explain the jump. And so what I'm asking you is, if you take away that say something line of cases, because that's about a different problem, what are we left here with? And I guess it's a version of the same question I asked Mr. Giesfeld. Is it your argument that since review of these revocation sentences is so differential, we leave to one side all the line of cases starting from Gall that tell us a judge does have to explain, and if there's a jump, the greater the jump, the more the judge has to explain why the jump?
I agree that there has to be a greater explanation for the greater jump, and I think that's consistent with the case law. You're correct, Your Honor, about Martin. That was a failure to calculate the guideline, and the district court failed to comply with the with that particular requirement. And that's not what we're getting at here. I think the recognition of the guidelines is kind of a building block that gets us to the explanation. So I won't belabor that as one of the building blocks, but what you're really getting to, I think, Your Honor, is what did the defendant say, or what did the district court say that really addressed the why? And why was this a case where the district court felt there was a need to go above the sentencing guideline range? And I want to respond to what Mr. Giesfeld said. I think the district court took issue with much more than just the home confinement in this case. I think the central focus of the transcript here was the district court not only trying to make a record for appellate review, but also trying to get Mr. Snake to understand why the court was going to do what he did. The district court was talking directly to Mr. Snake, and I think the judge finalized and said, I hope you understand, and I hope this gets you to change your conduct, because I don't believe you. Actions speak louder than words, and you can sit here today and say that you now understand, but I gave you a warning. He's a child sex offender, right? I gave you a warning not to have contact with minors, and that was one of your conditions of supervised release. You violated it. We brought you into court, at least on a telephonic, and I gave you a verbal warning, and you didn't take heed.
Do we have any information on where the judge gets 24 from?
The number 24, Your Honor?
No, we all know it's the stat max here, but
Correct.
do we have any information in this record, in this transcript, on where the judge gets 24 from?
No, I don't think the judge, and in my experience, judges oftentimes don't weigh, it could be 16 or it could be 18. I think the judge just thought, based upon the egregiousness of the conduct, and I will note that the judge said at least 3 times, it was my count, 3 times in the transcript, he called the defendant's behavior egregious. And I know you'd mentioned, Your Honor, the words about the most dangerous sex offenders. Really, he's talking about predators who are grooming children and using leadership roles to have access to children, not telling the children's parents that you are a child sex offender who's taking care of their kids. That is a consistent theme throughout the...
Right. Is there any place in the transcript where the judge acknowledged what he was doing was way above the guideline?
I think the summary at the end, I think, kind of brings it together, where the judge says, I'm persuaded that a sentence above the advisory guideline sentencing range is reasonable and no greater than necessary, and of course we're talking about the maximum, to achieve the statutory purposes of sentencing upon revocation. The judge said, the intent of my sentence is to hold the defendant accountable for his violations, protect the community, and specifically minors, as well as to promote specific and general deterrence. And those...
I hear you. Could you address the Lockwood case, which was highlighted in the opening brief, but not mentioned in yours?
Yes.
And it feels a lot like this one.
The Lockwood case is a case where the district court focused almost exclusively on the defendant's criminal history, and this court found that the lack of record in the district court, considering the defendant's mitigation arguments, which I think the district court forgot until the defendant mentioned it, left this circuit unable to meaningfully review the sentence. So it was really where the district court focused on criminal history, like criminal history points.
Well, no. I'm going to the passage on 781 in that opinion, where the district court imposed a sentence nearly 3 times the high end of the guideline sentencing range, and this is at 781 in volume 789 of F3rd. And the point was not that the higher sentence could not be justified. It was that the district judge did not specifically address, why am I going nearly 3 times the top of the guideline range?
And I think the defense argument is, and I hope I'm not getting this wrong, was that the court failed to offer a compelling justification, but it's more of an explanation. And the higher the...
Exactly. That's the argument here.
Mm-hmm. And in this case, I think the judge did. I think the judge clearly talked about the 3553 factors, what he was trying to do, hold the defendant accountable. Why? To punish him. It's a 3553 factor. Protect the community, specifically minors, from a child sexual offender who's having repeated contact with minors in violation of the supervised release conditions. That is protecting the community. Specific and general deterrence, getting a message through to the defendant. And the judge actually at the end again said, I hope this gets a message through to you that your actions are not acceptable. So the government's position is that the record as a whole adequately supports and addresses the sentence in this case, as well as the upward departure, including the amount of upward departure. So for those reasons, unless there are further questions, we would stand on our brief and ask that you affirm the sentence.
Could I ask you about your quotation of the Martin case at page 12 of your brief?
Yes. The one where we neglected a string citation?
I don't know what your explanation is, but the quotation is not from Martin?
That's correct. We acknowledge that and apologize.
Okay, I hadn't heard that before. It came up in the reply brief, and I hadn't heard anything mention of it until you're ready to sit down.
Okay, I apologize, Your Honor.
All right, thank you, Mr. Steffen. Mr. Geisfeld.
Thank you, Your Honors. Judge Hamilton, first, the court did not ask if all of the main sentencing arguments were addressed. I just checked the transcript.
Or if the explanation was sufficient.
Correct,
okay.
Yes. The government came here today, Your Honors, and said, I think the central focus of the sentencing was, and then gave its explanations. The question is not whether a sentence could be explained. The question is, was it? We don't scour the record. We do for other factors. Did you consider the sentencing factors? That's okay. But here we needed an explanation. And in the comparator cases that the defense put forward in the original brief, Lockwood, Snyder, Castro Juarez, all of them had instances in which the sentencing court did address some information, did address some record, put forth some reasoning as to why a particular sentence might be appropriate. But all of them were examples where ultimately, at the end of the day, the sentencing explanation was insufficient under Gall. The government says that the word egregious comes up several times in the sentencing transcript. The government's right on that, but we don't know what this district court was applying its egregiousness descriptor to. Was it?
How could that possibly be the case? Are you suggesting that the judge has to say, I'm sentencing the defendant 24 months because this. I'm sentencing the defendant 24 months because of this.
No, we're not suggesting that there is a magic words argument, Your Honor.
I mean, the judge, like public corruption cases, the judge talks about evil of public corruption. And then at the end, the judge says the sentence is 60 months in prison. Does the judge then have to say 60 months in prison because, you know, I start and then I say 60 months and then I got to say it again?
Absolutely not. I would just point to, as I mentioned in my opening argument, the actual transcript reveals that the topic that the court was referring to was home confinement. It was bookended the discussion, and it wasn't until there was no change of direction from which that this court could find or even infer what specifically was the court's reasoning. Thank you very much.
All right, thank you, Mr. Giesfeld. Thank you, Mr. Steffen. We'll take the case under advisement of the court.